Welcome to a presentation on contract laws in India. I am Asha, Assistant Professor from Kristu Jayanti College, Bangalore. In this presentation, let us understand the meaning of contract, definition, the difference between contract and agreement, and the contract laws in India. To move on, first let us understand what do we mean by law. Law is a set of principles or rules and regulations that have to be followed by every citizen in order to have justice in the society. So, what is business law? It is that branch of the law which is connected to industry, trade, and commerce. So, law is nothing but a set of rules and regulation, a body of principles that governs every citizen in a country. And every law that is connected with business is called as business law. So, talking about contract law is a part of business law, and this contract law comes under the Act, Indian Contract Act of 1872. And Indian Contract Act of 1872 is based on English law. It originated from English law. Now, this contract law lays down certain principles governing all the contracts, but it does not give the rights and duties to the parties. It just lays down the principles and tells what needs to be followed by the parties in the contract. And it has 266 sections. It is a general principle of law. It has law relating to sale of goods, special kinds of contracts, and also contracts in connection to partnership. So, what do we mean by a contract? In simple terms, a contract is an agreement between two parties where this agreement gives rise to obligation which needs to be fulfilled by both the parties, and this is enforced by law. So, contract is an agreement which is enforceable by law. The Indian Contract Act of 1872 defines this term contract as every agreement that is enforced by law. So, according to Sir Frederick Pollock, he says that every agreement and promise enforceable at law is a contract. So, in simple terms, an agreement that is enforceable by law is a contract. So, we see two terms under contract. So, contract is equal to agreement plus enforceability. Now, what is the objectives of having this contract? The objective of having a contract law is to make sure that the parties in a contract fulfill the promises that they make in a contract. They need to keep up their commitments, they need to fulfill the promises that they make in a contract. So, this law makes sure that the parties to a contract keep up their promise. And it also makes sure that if a party fails to keep up his promise or his commitment in a contract, there would be penalty and compensation, which gives a seriousness to this agreement and makes sure that the parties in a contract fulfill their promises. So, we learn about two terms under this particular contract. One is called as agreement, and the other one is about the enforceability. So, what is this agreement? Agreement is nothing but an offer or a proposal that is being made by one party to another party, and the other party accepts that particular proposal. So, when a person signifies his willingness to enter into a contract with another person and the other person gives his consent to this contract, then we call it as an agreement. So, agreement has two terms, one is offer and the other one is acceptance. So, there must be one party who makes a proposal and there is another party who accepts this proposal. And when a proposal is being accepted, it becomes a promise. And every promises leads to consideration to the other. Okay, so it forms consideration, and each one has an obligation which they need to follow in the contract. And there is another important term in an agreement which we call it as consensus ad idem. So, what is this consensus ad idem is? In every agreement, both the parties must agree upon the same subject matter in the same sense at the same time. It simply means that it is meeting of minds, which means both the parties must agree upon the same subject matter in the same sense. For example, if a person owns three cars and if he wants to sell one of the cars, he must be very specific in saying which car he is selling. So when he says, "Will you buy my blue car?" and the other party says yes to it, there is consensus at item because both the party know which car they are selling and they are buying. That is called as consensus ad idem. If there is no consensus ad idem, there cannot be a contract. So there has to be meeting of minds among the parties in a contract. So here there's an example for agreement. If A has contracted with B for purchase of 10 bags of cement of a certain quality for rupees 1 lakh, in this particular case, one party is selling the cement and the other party is buying the cement. So a party is selling the cement, which is a consideration to the other party, and another party is giving 1 lakh to A, which means that it is a consideration that is given to A. So in this case, both of them have an obligation and commitment to perform. This is an agreement. And another important concept is there must be enforceability at law. So what do we mean by enforceability at law? It gives rise to a legal obligation. So there is a commitment among the parties to fulfill their obligation in the contract, failing which they can be penalized, they will be taken to the court of law. So in this case, we need to understand that there are two types of agreements. One is called a social agreement and the other one is called as legal agreements. Social agreements are those agreements which are created between friends or any immediate relationship which is not leading to a legal relationship in the agreement. Now, social agreements cannot be enforced in the court of law. For example, Mr. Vijay invites Mr. Ajit to a dinner at his house. This is a social agreement, a domestic agreement which cannot be enforced in the court of law. So, this kind of agreements just remain an agreement and they do not become a contract. So, if it has to become a contract, it must give rise to a legal relationship. It must be something which is accepted in the sight of law and which will be enforced in the court of law. Only then it will be termed as a contract. So, all agreements cannot become a contract, but all contracts will definitely have an agreement in them. So, contract is nothing but an agreement plus enforceability by law. So, by this, we understand the meaning of contract. Thank you.